Excellent. Good evening, everyone. My name is Christopher Dustin. I'm the chair of the Thompson Inland Wetlands Commission, and I am calling this special meeting of the commission to order on May the 22nd, 2024 at 7:02 p.m. This is a hybrid meeting with both in-person attendance and attendance via Zoom. The meeting is being recorded. Zoom access and the recording are under the control of a Zoom host for whose services we are grateful. For improved sound quality, we ask that all Zoom participants please remain on mute unless it is your turn to speak. You may leave your video on or off, though we ask that you turn your video on when you are speaking. If video is not an option for you, that will not preclude you from speaking. In a moment, I shall review the protocols for speaking at this meeting, who is welcome to speak and at what time. In the meantime, I want to remind participants that anyone who attempts to speak at a time other than that specified by these protocols speaks out of order or in an inappropriate manner may be asked to leave the meeting or be ejected by the Zoom host. I shall now call the roll. Commissioner Chapin. Present. Commissioner Morano is not present, I believe. Commissioner Obert. Present. Commissioner O'Neill.
Present.
No alternates present, and we have a quorum. Tonight's special meeting begins with a public hearing over which I shall also be presiding. The purpose of this hearing is to receive testimony, hear comments, and take questions on proposed revisions to the inland wetlands and watercourses regulations for the town of Thompson, as well as a new inland wetlands map and application forms. The proposed regulation revisions and map were filed in the town clerk's office and posted on the town's website on April 23rd, 2024. On May 10th and again on May 17th, legal notice of this hearing was published in the Thompson Villager, a newspaper with a general circulation of Thompson. The notice, which I am required to read, as I understand it, is as follows. Thompson Inland Wetlands Commission notice of public hearing. The Thompson Inland Wetlands Commission will hold a public hearing on amendments to the Thompson Inland Wetlands and Watercourses regulations and the Inland Wetlands and Watercourse map on May 22nd, 2024 at 7 p.m. in the Merrill Saney Community Room, Thompson Town Hall, 812 Riverside Drive, Route 12, Thompson. Proposed regulation amendments involve every section of the current regulations, including but not limited to adding new definitions, deleting and modifying definitions, the elimination of applications for conceptual subdivisions, revising the requirements for application requests, resulting in a restructuring of application request forms for jurisdictional rulings, wetlands agent approvals, and permits. Modifying the authorized actions of the wetlands agent, a new fee schedule, revising bonding requirements, amendments to comply with statutory changes since 2009, and the correction of Scrivener errors and structural inconsistencies. The proposed regulation amendments and map are available for public inspection in the office of the Thompson Town Clerk and are posted online in the Inland Wetlands Commission webpage at https://www.thompsonct.org/inland-wetlands-commission. Citizens may attend and offer comments on the proposed amendments. Christopher Dustin, Chair. This public hearing is now open. As the first order of business, I'll ask Marwa Butts, acting as the commission's duly authorized agent and engaged by the town to steer this process, to enter into the record hard copies of the published legal notices and documents posted on the Town of Thompson's website for public comment and provide a summary of the changes being proposed. I shall also ask her to read and enter into the record any letters and emails received in response to the commission's request for public comment on these proposed revisions. Ms. Butts, acting as the commission's agent, will then be asked to respond to comments received prior to this meeting and may offer additional exhibits related to her response. Following Ms. Butts' testimony, the commission will be happy to receive additional comments on the proposed revisions from those in attendance tonight. At that time, I'll briefly pause the hearing and ask anyone wishing to speak to please print your name and address on the speaker list located at the end of the table there. Speakers will be heard in the order in which their names appear on this list. I'll ask that you please wait to be recognized before speaking and direct your comments to the chair. After the first round of in-person comments, citizens attending via Zoom who wish to speak should indicate their desire to do so by using the raise hand function. The Zoom host will compile a list of those who wish to speak via Zoom. Those participants will be recognized in turn, at which point they should unmute their microphone and provide their testimony. All speakers need to clearly state and spell their name, yes, it's obvious, and address prior to offering comments. All comments must be specifically related to the subject of this hearing. Where there's a question about a request for clarification of the proposed revisions, I shall determine if it's appropriate for Ms. Butts to address the question or for a commissioner to respond. I'll ask my fellow commissioners to refrain from any response until I've made that determination. Citizen comments will be limited to one 5-minute time allotment with an additional 3-minute allotment for a second round of comments if needed after everyone has had the opportunity to speak once. And since these proceedings are being recorded, I ask that you please state your name each time you begin to speak. Following close of the hearing, based on the comments it's heard, the commission will deliberate on any proposed changes about which comments have been made. The commission may render a final decision on these changes during the time set aside for discussion and deliberation, or defer such a decision until its next meeting. And I'll ask that you be advised that the opportunity for public comment on these revisions is during the public hearing portion of this meeting. Once the hearing is closed, there will be no further opportunity for public comment at this meeting. The purpose of the public hearing is for the commission members to listen and attend to citizens' comments and address requests for clarification as appropriate. The commission will consider these carefully as it deliberates on the proposed revisions. Are there any questions regarding this procedure? I apologize for the long preamble, but it's ground we have to cover. I'll now ask Ms. Butts to please, yes.
Yes,
Commissioner Obert.
Charlie Obert, Commissioner. After this meeting concludes, these regulations, if they're acceptable to the town, become the revised ordinance?
We will, if at the close of the hearing, the commission will discuss and deliberate and settle on final language if we're able to do that tonight.
So the final vote is up to us after the public has had
Once the hearing is closed.
Okay.
Yes. Yeah. And
Thank you.
One of the things we'll have to decide upon is an effective date for those revised regulations. Any other questions regarding the agenda of the proceedings? Okay, then I will ask Ms. Butts to please read and enter into the record hard copies of the published legal notices for this hearing.
So if you don't mind, I would like to do that as after I've entered the records that were the items that were posted on the website. If you don't mind. So the first item I would like to have entered into the record is the posting of the cover sheet for the proposed revisions to the Thompson and the Wetlands and Watercourses regulations with the print of the posted documents for the public hearing. So if you pass that around, the commission can see what that exhibit is that I'm offering. That was the front page on the posted document. And all commissioners should have received a copy of that posting also independently via email from me. The copy that you have is also the one that was stamped by the town clerk. The copies that you received in your packets, I don't believe have that posting. That's to verify when it was posted at the town clerk's office and at the same day it was posted on the website. Second exhibit I offer is the posted draft of the Inland Wetlands and Watercourses regulations, the black line version. This is the version that contains all of the revisions that were agreed upon by the Inland Wetlands Commission for public review and comment and this public hearing. Charlie? The next item is the proposed new inland wetlands and watercourses map for the town of Thompson, dated revised October 20th. A copy of this was placed on file with the town clerk, along with a small copy that was 8.5 by 11 that was posted on the website, electronic version. And I offer this as exhibit 3. This map was generated by Carolyn Wurge, who was a GIS, who knew GIS, and she took the assessor's layer and added it to the soils layer that was originally developed by NRCS, Natural Resource Conservation Service. And this was generated before she passed away. It also identifies the 10 significant wetlands on it, which is in addition to what the original map had. The original map did not identify the location of the individual significant wetlands with the letters that were associated with the study that was done in 1980. That's exhibit 3. Then I offer exhibit 4 is the posted Thompson Inland Wetlands request for regulated activity license and jurisdictional ruling base form, 5 supplemental forms, a request for permit extension form, request for transfer of permit to new landowner form, and a request to modify permit form. These were the ones that were also posted on the website, public comment. And that would be exhibit 4. They are identified as draft at this time because they have not been finalized or approved by the commission in a final form. Exhibit 5 would be the Thompson Inland Wetlands and Watercourses regulations drafted that were posted on the website in a red line version. This shows the changes, strike out in red, underline in red for that which is added. And it contains also comments that I made along the way explaining why changes were made, as well as comments that I had put in based upon conversations and communications with the town's attorney, Kenneth Slater from Halloran and Sage. The copy that you have in your packets that I gave you are not actually redlined. They're gray. I didn't have the ability to color copy those. For exhibit 6, I offer the listing, the posted listing of changes from the 2009 revision of these regulations. It identifies every place where there is a modification of the 2009 regulations. Next would be a printout of page A10 of the Thompson Villager as Exhibit 7 that was published, the legal notice being published on May 10th, 2024. And accompanying that would also be a printout of page A11 of the Thompson Villager printed on May 17th, containing the second legal notice for this public hearing. And that would be Exhibit 8. I'll offer those two together. I will note when the first legal notice was published, they had failed to identify the second publication date. And I emailed the newspaper and said, are you publishing it a second time? And they corrected the error. So on the second notice, you will see 2 dates for publication as opposed to 1 that was only given on the first one. A failure to publish a second time would have prohibited the commission from holding this hearing at this time.
Thank you for catching that.
I should have highlighted in yellow so you could have found it a lot faster. Print is very tiny, but that's the easiest way for me to get proof of publication. Next, Exhibit 9, I offer a printout of an email from Tara Pengizik, Thompson's Director of Planning and Development, with a printout of an attached file, draft proposed IWC regs revision -T-Pen markup PDF. I offer this as Exhibit 9. You also have a packet in copy in your packets that I gave you tonight. So later when you want to look at them, you can look at the copy that's in your packet. But I would request that the exhibit go into the file for the record. It should be there in the back of your.
I got it
packet.
right here. Yeah, it's right here.
Next, for Exhibit 10, I offer a printout of a May 21st, 2024 email from Janet Blanchette to email address wetlands@thompsonct.org with a printout of an attached memo dated May 21st, 2024. In that memo, Ms. Blanchette requests that the hearing be kept open to provide for additional time for review of the regulations.
I have a question. On the note that we just referred to, there's a suggestion about contacting local soil scientists, planners, surveyors, engineers. The proposed changes to solicit comment. I know we've been working on this for years. Did we also avail ourselves of some of these other resources?
Marla Beth speaking. The answer is no.
Thank you.
And then finally, I offer a printout of email threads between DEEP staff and myself from April 12th to May 22nd. In summary, and this would be Exhibit 11, You should have a copy of that in your packets. Originally, I had emailed, as required by DEP's administrative regulations, a copy of the draft legal notice and the regulations, proposed regulations, along with a red line version and black line version and the revised map in PDF form, and an explanation of the changes for the public hearing. And also, not hearing a response from DEP, I sent them an email on May 10th and asked what the status of it was, because I had not gotten confirmation that they had received it. I got a reply back that they would look into it, and they'd get back to me and thank me for reaching out to them. They then got back to me on the 16th of May and said that they would be meeting with Kristen O'Neill, the new Wetlands and Watercourses Program Coordinator, to review the regulations, and they'd have comments back to me before May 22nd. And then I subsequently got an email. I sent an email the next day asking if, to have Ms. O'Neill contact me if DEP finds any language that DEP is going to mandate a change, so that I can understand the basis for such required change. Thank you for the help. I did not hear anything until May 21st. The thread states, we've started our review on the proposed new regs and have several things to discuss, but we won't finish a review before your public meeting opens tomorrow. We have scheduled 2 more meetings on our end to continue the process and would appreciate it if the public hearing was kept open. We have comments to you for the week. We'll have comments to you for the week of June. And at that point, we'd like to schedule a meeting to walk through our suggestions to you. Please feel free to reach out with other questions, and thank you for your patience. I then called Ms. O'Neill and had a conversation, explained to her that it was not very timely, and I felt it was necessary to follow up with an email to her confirming the conversation. And this is what I wrote. I think this is important because the concern is that DEP has a requirement to review the regulations to get them at least 35 days in advance of the public hearing. But the question was then becoming, were they going to find anything in there that was in non-conformance? So I sent her an email, and I'm going to read this to you. This is to confirm our conversation at 1:30 p.m. today and my anticipated course of action regarding DEP's failure to provide a timely review of Thompson's proposed inland wetlands regulation revisions. It is my intention to advise the Thompson Inland Wetlands Commission to proceed with rendering a decision on the draft regulations and the new map based on the comments placed in the hearing record tomorrow night, and not to hold the hearing open for an undetermined later date. The proposed regulations have been reviewed and adjusted based on the legal advice of Kenneth Slater of the firm of Halloran and Sage. Should DEP find that any language is non-compliant with the statute or its regulations, it can issue a notice of non-conformance in accordance with section 223911 of the regulations of Connecticut state agencies. When I called you today in response to your email sent this morning, I advised you that I am under contract with the town of Thompson to secure revisions to the regulations, and that contract expires on July 1st. I'm further scheduled for surgery on June 20th and will be limited to perform activities under that contract after that date. DEP's review is untimely. The proposed regulations, new map, draft legal notice for public hearing is scheduled for May 22nd, and the documents identifying the changes between the current regulations and the proposed changes were submitted electronically on April 12th as required by DEP's webpage. And then I cite the webpage. By May 10th, having received no confirmation of receipt of my 4/12/24 email, I emailed Mary Beth Hart to verify it was received, to which she immediately replied that she would look into the matter. By email May 16th, Mary Beth said that you would be in contact with me. I emailed a reply the following day and requested that you call me if you found any language that DEP is going to mandate a change so that I can understand the basis for such required change. Today, you sent me, and this is yesterday's date, today you sent me an email stating that you had just started the review and would not finish before the public hearing. My call to you did not result in identifying any area of possible nonconformance. Unless I receive a notification that there's a possible issue of nonconformance, I will advise the commission to proceed with closing the hearing tomorrow night and let DEP pursue its administrative remedies for any non-compliance issues subsequently found. I am more than willing to volunteer my time to discuss the language of the proposed changes at a later time if that is of help to you in understanding the proposed changes. I worked 32 years with the Inland Wetlands and Watercourses Act and the associated regulations of Connecticut state agencies and understand that it is a complex matter and you are new to it. And to that end, subsequent email, I sent to Mary Beth Hart, who is the supervisor of the wetlands program. And I said, hi, Mary Beth, I just left you a lengthy voice message. I believe RCSA section 22-839-11.5.b, final written approval does not apply in this instance because the RCSA section 22-839-11-4A distinguishes between adopting and amending regulations. And the RCSA section 22-839-5B refers to approval required prior to adoption. So am I correct that DEP is not required to approve the regulation revisions in order for them to become effective? And that if DEP finds subsequent non-compliance issues, it can take action under section RCSA 22-839-11.3. And I have a question mark there. See my email to Kristen below. A response by tomorrow noon would be most appreciated. Sorry for any problems this may have caused. It might be helpful if we could do a follow-up meeting regardless of what happens at tomorrow night's hearing in Thompson. To which she replied today at 11:10 a.m. Good morning, Marla. Thank you for the update. DEP is not required to approve regulation revisions, but we will reach out if we have any questions, concerns, or comments. Sincerely, Mary Beth. So I offer that as exhibit 11. And that is the end of the exhibits that I have pre-identified. Because Tira Pengisik's comments are extensive and my comments back to her are extensive, rather than making the public wait till all the comments go through, I would suggest that the public state whatever concerns or they have, and then I can incorporate those into final comments that I would have regarding Tira's comments, as well as any questions about extending the public hearing.
Okay, toward the,
Yes,
after the public.
after the public
Opportunity
speaks,
for
yeah.
input. Thank you. I would at this point, before I open the hearing to public comment, I would like to take a moment to acknowledge and welcome Thompson's newly appointed inland wetlands agent, Margaret Washburn, who is with us tonight. And Ms. Washburn, would you like to provide the commission with any comments or testimony regarding the subject of this hearing?
This is Margaret Washburn speaking. Thank you very much. I have a few comments, and some of them are questions, some of them are comments on about half a dozen pages, and I'm not sure, I don't think this would take too long, and maybe I'm not sure the public hearing is the format for some give and take, but I'll just go ahead and why don't I just wade in here? It's the first one is, I looked at Tira's comments and she likes the term officer versus wetlands agent. My last position, I was one of the hats I wore was wetlands enforcement officer. And I do represent the land use law enforcement. And I would be more comfortable with keeping the title of wetlands enforcement officer moving forward. That's not sure why Marla wanted agent versus enforcement officer, but it seems like it gives me a little bit more, makes people recognize that I'm an enforcement officer, just which is the fact. Then I had a question on page 10 of the one, not the red line version,
Black line.
right? Which I talked to Marla briefly about, that agent approval in many towns requires the chairman to sign forms for work in the plan review area, and I know I'm looking at the new form here, and it doesn't seem to have a signature block for the chairman, but it says here in the last line on the
I'm sorry,
first paragraph,
Mark, can I interrupt? You say page 10, cite the specific.
section 5, section
Oh.
4.4.
Okay,
Up at the top, the very first paragraph, the last line, it says the last sentence, the wetlands agent for the commission may make such a ruling for activities in the upland review area on behalf of the commission at any time in consultation with the chairperson of the commission. So I'm just looking for a little clarification about what's consultation versus him signing off.
So Marla Butt speaking, if I may. So consultation means you contact them and they say, yeah, that's fine. So it doesn't require the chair to come in to sign a document. All it needs is just an approval. And since it's just work in the upland review area, it's not actually in wetlands or watercourses for that kind of ruling. So that's what communication would mean.
Okay, so an email would.
Email
give
is
us proof
sufficient.
that he or she was consulted.
Yep.
Okay, thank you. Now on page 11, section 7, application requirements, 7.1. Eight lines down, the first word is regulations, period. It says any materials submitted that fail to include either the required application form, application fee and or drawing may be summarily rejected and returned to the submitter with an explanation for its rejection as an application. And my question is it the intent here to be rejected by the agent / officer or by the commission or both or either?
Ms. Butt,
Marla Butt
feel free to
speaking.
reply.
The answer is by any of them. So because the application is for jurisdictional ruling, wetlands agent approval or an individual permit. If the fee is not there, the agent identifies that the fee is not there. If the form is not there, the agent identifies if the form is not there, and the agent would then summarily reject it. Or alternatively, the agent could bring it to the attention of the commission at the next regularly scheduled meeting and ask the commission to decide on its rejection, as opposed to being processed as an application, incomplete application.
So I can Margaret Washburn speaking, just to make sure I'm interpreting this correctly, which appeals to me, that if I get an incomplete application, I can return it to the submitter with an explanation about why it's being rejected. Is that correct?
Marla Butt speaking. That's not quite exactly correct, because you can have an incomplete application but all the three pieces are there. So to be construed as, if you look at the definition of application in the definitions section, which you'll find on page 2 of the black line version, application means the submission of documents that includes 1, a completed application form, 2, the requisite application fee, 3, a scale drawing of existing and proposed conditions. That if that minimum information is there, it's an application. But if they are missing pieces of, like you need a soil science report, that's an incomplete application. That, as long as those other 3 components are there, a drawing, a fee, and a form.
Margaret Washburn speaking. And excuse me if I know I'm detail oriented, but this is my chance to ask these questions now, and this is gonna be my job. If the drawing is not to scale, as called for in item 3 under application, a scale drawing, in that case,
It
I
could
would
be-
ask for a better drawing rather than rejecting it.
You could do either.
theoretically. Okay,
You could do either. It's, as you'll see later on, it said alternatively, the materials submitted may be accepted as an application for processing and the applicant requested to complete the application following the data receipt. So you can do it
very
either way.
often happens, right?
But in that case, you would not process the fees. You wouldn't, if they sent in a check with it and you're rejecting it, you want to return everything back.
Right.
Yeah.
Thank you.
Commissioner Ober, you had your.
Yeah, I have a question. we're looking at a copy that has handwritten notes on it and,
That's Tira's.
Yeah, that's.
okay, but I coincidentally, I'm following along and seeing the same things. So, they should be in this, right?
Yeah, that's the red line version. You want the
Yeah.
black line version.
I read it online.
Yeah.
But I haven't looked through these tonight.
They're the same ones that you had looked at before
Yep.
and when you found that the regulations were acceptable to go to public hearing.
Yes.
Margaret Washburn. Page 12. That very top, 7.4, section 7.4. This one sentence reads, the commission and the applicant may hold a pre-application meeting to determine whether or not the proposed application involves a significant activity. And Kira had written in this should be the officer, and then I'm thinking, my note says commission and or the agent / officer. Because it seems to me a pre-application meeting could very well be held with the agent / officer.
So the purpose of the pre-application, Marla Butt speaking. The purpose of the pre-application meeting is not to review the application for completeness, but is to determine if a significant activity exists. And only the commission can determine whether significant activity exists. That's not to say that the agent couldn't have a meeting with the applicant to give them some advice as to how the commission might view it. But it's not the responsibility of the agent to make that determination whether significant activity is occurring or not.
Thank you. This is Margaret again. Only see the Conservation Commission the Wetlands Commission can deem significant activity. Then on the next section down, 7.5 B and D. Would it be possible to ask for email addresses as well as the name, mailing address and telephone numbers?
You look at the application form, Marla Butt speaking. Application forms. I believe it's listed as an option. This probably doesn't have it. Right. Yeah, so, we list the email address as optional, not as if you look at the application form, the base form.
So everyone this is Margaret, everyone has to submit the base form along with whatever other,
Correct.
okay, and so it's,
Listed as optional. Because not everybody.
You're on that one.
where is it?
It's in the forms. There's a pile.
Which one?
It's
I'm
the base
just looking
form,
for where it says.
base form.
Oh, email optional.
Mhm.
Okay, thank you. See that? Getting close to, I'm at least halfway through, Margaret Washburn, so thank you for bearing with me here.
Not at all. It's very helpful.
On page 18, section 8.6, it's a very short sentence. All applications shall be open for public inspection. And Tira had written maybe that word, it would be better if it said all applications shall be available for public inspection. I kind of agree that there might be a better word than open.
Marla Butt speaking, I have no objection to either word. It is used several places in the regulations, but the commission could decide if they wanted, that it was more appropriate to say available as opposed to open. They'll have to decide that.
Okay, then on the same page, 9.1. The first sentence states, the commission shall not hold a public hearing unless the commission shall not hold a public hearing on an application for a permit unless. And Tira had written why would you phrase this as a negative? And I know it's a carryover from previous language. And she suggests the commission shall hold a public hearing when any of the following apply. And I think that would probably be better language, not to have that in the negative myself, just a suggestion.
So I can respond to that now, or I can respond when I get to Tara's comments. I can do that now. Would you prefer I do it now?
I think you should do it now, but
Okay, we are on 9.1. Okay. Tara questions why the phrase "the commission shall not hold a public hearing" is phrased in the negative, and shouldn't it be "the commission shall hold a public hearing if any of the following apply"? The drafted language found is found in section 22A-42A subsection C subsection 1 of the statutes. Tara's suggested language would not prohibit the holding of a public hearing, and doing so would cause a violation of the statute. Tara's suggested other changes appear to be wordsmithing, and I have no recommended change to the, I recommend no change to the posted language. Remember that the negative, if you say the negative, it doesn't necessarily mean the affirmative. The commission shall hold a public hearing if the following things exist. If you say they shall not, unless it exists, means there's no other conditions that you can hold that public hearing. And that's the language in the statute. So the languages in the regulations is a repeat of the language
Right.
in the
I
statute.
understand.
Because there was specific statutory language, because they did not want commissions holding a public hearing unless there was a significant activity, or unless they felt there was a public interest, or they got a petition. Those are the three instances that they said that's the only way that you can hold a public hearing.
Okay, thank you. This is Margaret. Now, again, in section 9C, the second sentence,
9(1)(c).
9(1)(c) on page 18.
Yep.
There's just the word provided appears twice in the second sentence there. The commission may issue a permit without a public hearing, provided no petition provided for in this section. And she had crossed out the first provided and wrote in the word if. It just does, it seems to me it's a little bit easier to read. So again, I don't, I'm almost at the end of the wordsmithing, as you put it, but I do think that having the word provided twice, if you could just cross out provided and put if, it's a shorter word, and it seems to make it an easier sentence to read.
Marla Budd speaking. Yeah, I can see how it, by crossing out the second provided, doesn't change the implications of the sentence.
Sure.
yes.
George
Commissioner
O'Neill,
O'Neill.
I have a question.
Yes.
That seems, on its face, it would appear to be more simplistic. However, by being more specific and including the second provided, that confines the range of possible items that could be used to prevent or permit. So I would.
It was the first, and excuse me, Margaret Washburn, it was the first provided that Tara had. So the sentence would read, the commission may issue a permit without a public hearing if no petition provided for in this section is filed with the commission. It's just a suggestion. Commission can do what they want with it.
Thanks. Thank you for the clarification.
Don't mean to split hairs
Kind of
here.
best in speaking, and perhaps the English teacher in me, but the first provided should actually have a provided that.
Yeah,
after.
that's what I thought.
I'm not gonna touch.
Well, that would clarify, Commissioner O'Neill.
There you go. You've got options. This is Margaret. I'm almost done. Page 25, section 13.3A. That's the first sentence is hard to understand. Surety bonds are not permissible by right as a financial guarantee, but can be approved at the discretion of the commission if in the form of an acceptable financial period. Something seems,
Complete sentence.
Marla Budd speaking. This language was specifically edited by Attorney Slater. If you look at the annotated version, the red line version, in the comments section, he wrote, he said on March 5th, 2024, Attorney Slater comments, quote, surety bonds are terrible. Carriers stand on head to deny payment. That is why on zoning side, a commission can refuse, accept a surety bond, but must approve a financial guarantee in the form of a cash bond or a letter of credit. It was very specific about the language.
Is it missing a word guarantee at the end? From what you just said, this is Margaret,
Percent.
an acceptable financial guarantee? Because the financial is not really a noun.
It is, Chairman Dustin, it is an adjective. It can be used as a substantive, as some adjectives are, but I wouldn't understand that usage.
Where are you referring to?
The first sentence in 13.
A, 13.3A,
The
purpose-
last word in the sentence is simply financial. And the question is, should there be? Is the word guarantee meant to follow the word financial? Or-
if it was right here.
Yeah.
Wait a minute, maybe there's a problem with the red line
If in
version.
the form of an acceptable financial period.
I think,
Oh, I see what you're saying.
Doesn't say financial guarantee, doesn't
I,
say.
yeah, and this was
financial.
language that he gave me, so,
right, and this is Margaret, and so when you read what he said.
Yep.
Wrote, you said the word guarantee, and then
Guarantee.
it all made sense.
yeah. Okay, so,
Is that not supposed to even be there, the sentence?
Well, I mean, it goes into that in the second sentence, a financial guarantee.
Yeah, so there you go, guaranteed,
Right.
Margaret speaking. With the suggestion. Now, this is Margaret again. I had a question, last 3 days have been sort of circuit, major information input for me, so I know I talked to Marla, we touched base about the concept of conceptual subdivisions. Do these regulations kind of dispense with conceptual subdivisions for the Wetlands Commission?
Marla Beth speaking, yes, they do.
And is a conceptual subdivision still something that the Planning and Zoning Commission could approve?
Planning and Zoning Commission gets a conceptual, I don't know how their rigs read for conceptuals. The statute reads that if Planning and Zoning Commission gets an application for a subdivision, and if the land that is the subject of the subdivision application contains any wetlands or watercourses, it must make application to the Inland Wetlands Commission, regardless of whether or not they're proposing to alter it or not. So in the case of a subdivision coming in that has wetlands on the property, but nothing is proposed, they would seek a jurisdictional ruling because that's an application, and could get a ruling from the commission that there's no regulated activity, the commission has no further comment. If it has activities in the upland review area or activities that are actually in wetlands or watercourses, they would have to submit an application, the base form plus the form for subdivisions, which then bases the fee on what the activities are that are regulated.
I understand what you just said, but I'm still trying to, I can't understand going from the previous version of the regulations, and bear with me again, this is Margaret, because my brain just might be full, I still can't quite grasp how, so in other words, if someone came in with a plan is what we looked at, like the application we looked at this week for 4 lots on Passay Road, which is a seemed like a conceptual subdivision.
That's the way she submitted it under the current regs. Under the new regs, it would come in as a permit application for a 4-lot subdivision. That would be the base form plus, I believe it's supplementary form E. And they would receive a permit. See, under the current conceptual subdivision approvals, there is no permit issued.
Right, so if, Margaret speaking, if someone came in with some similar plan, but there's no work in the upland review area at all, then they could still ask for, or they would still need to submit the form for a
Jurisdictional ruling.
Right, which I call declaratory
Right.
ruling. Okay, I see. Thank you for that.
Now I have a question. Charlie Oberclear. So the reference was a development proposal with 4 lots.
Mhm,
And we granted a permit under the new.
mhm.
And if they come back and say, okay, lot number 1, if there is a wetlands, but we're way out of the 100-foot area.
Mhm.
That's dealt, each lot has to have its own permit. And the specifications, which we may have some jurisdiction over. Is if somebody says, yes, I wanna build it and I gotta build it 22 feet away from the wetlands. Then we decide, do they need to, or, you know,
This is Margaret, and so Commissioner Obert is bringing up a good point, and I thought I saw somewhere in here to the effect that after a conceptual subdivision gets approved, the commission decides whether or not they have to come back for individual
Under the-
permits for each lot. And
Marla,
they're
but-
going to have to.
Marla Butt speaking. Under the current regulations, that's the way it works. Under the proposed regulations, they would get a permit for all the lots. And that if they end up selling off one of the lots and there was a regulated activity, that permit is not transferable to that new owner. The new owner would have to come in for a new application. Under the current situation, since no permit is issued under conceptual, any regulated activity on any lot has to come back for an individual permit, not under the proposed layout. The proposed layout, they say get a permit for everything. The problem is when you do a conceptual approval, you've tied yourself, whether or not you've got all the information for it or not, you've tied yourself to that. You really have to go through a complete application process. And why are you making them come through twice? Coming through with a conceptual, paying a large amount of money, and then coming through with an individual permit for, or wetlands agent approval for each individual lot. That's the way the current system is. It's double dipping on the applicants. The current way would be, you have a developer who wants to develop a number of lots, comes in, gets a permit, and can do it. If he then subsequently decides to sell that lot, the person who buys that lot has to come back in and get a new license for that lot only.
okay, Charlie over here. But we can't approve of an application unless they show what they want to do and where.
They're showing one way that the property can be developed. But when a developer sells a lot to somebody else, that new somebody else might want to develop it in a different way. And therefore it would need a new approval.
We ran into something close to that recently where a person was buying a lot that had an approved plan. But he wanted to change the plan, even though he hadn't acquired the land yet. The previous owner, he owns it now, but the previous owner had to file for a change on the permit to say, I want to push the house. And we looked at that and we said, yeah, that's fine. Then it all rolled forward. And that would be the same way that this would happen, as long as any changes that might be proposed to the original 4 lot has to come back, and they can't change it unless they come back to us.
That's correct.
Okay,
That's speaking. Thank you.
Margaret Washburn, is there a spot you can point to in these proposed regulation changes where that's discussed, described, please?
sure there is.
Under there is a section that says that lots and subdivisions are not, licenses are not transferable.
I saw that.
Yes, and that's the reason, because of subdivisions, we cannot, we've been unable to track partial transfers of permits, and that's what it would be. Okay, 11.2, page 23. 11.2. No license shall be assigned or transferred without written permission of the commission. Partial transfer of a license for regulated activities is prohibited. So if a subdivision is coming in, page 23, paragraph 11.12. So if a permit is being issued for the entire subdivision and the developer sells off a lot, the new owner cannot come in and ask for a partial transferal of that license. They will have to apply for a new license. That's what that section means.
This is Margaret. The partial transfer refers to the fact that there were four were conceptually, for example, four were conceptually approved, and now I want to change one of those four. Is that what you mean by a partial?
No, under the current section, conceptuals, there is no permit, so there's no transfer. It's because there's no permit issued, and so they have to individually come in for licenses on each lot, whoever it is that has it. But under the proposed situation, there wouldn't be a conceptual. It would be the developer that comes in, gets the license to develop all the lots. If he wants to transfer, sell off a lot, and the new owner wants to do something, they would have to come in and get a separate approval. So it can be tracked.
This is Margaret. So the word partial there means, it doesn't mean that it's a part of the 4-lot subdivision. I'm just trying to get my head around what, I never really heard the word partial transfer before, that phrase.
So if a developer has the license and he sells off the lot, and the person comes in for a building permit for that lot, the building office will ask if there is a permit that exists for that development. And if it's not in the right name, the developer may say, I'm not letting him develop under my permit. That's not mine. So typically when they sell the lot, when they sell the lot, they know that they have to get their own permit, or that they have a permit already and it's transferred for that one lot. But if the developer has a permit that covers all the lots and he sells one, you're going to have a problem when it comes to the building office asking, is there a wetlands permit for that lot? And it'll be only in the developer's name, and that's not usually the person. If it's the lot that's sold, that's not the person who's applying for the building permit.
I understand.
So there'll be a problem.
I guess I'm still hung up, Margaret, here on what partial transfer of a license.
How can you transfer one lot on a permit
That is
of a
what
4-lot
we're talking about.
subdivision?
We're talking about the same thing.
Yeah.
I just wanted to make
Yeah.
sure that I wasn't missing some other meaning of partial.
Right.
Excuse me. Okay, last page 27. Excuse me. Section 14. 3A, B, and C. It's referring to hearings that are held by the commission within 10 days of the agent or enforcement officer issuing a cease and desist
Mhm.
or order to correct.
Mhm.
And in paragraph A, the hearing is referred to just as a hearing or the hearing.
Mhm.
In under B, I didn't notice the word hearing, but I'm sorry, it's in 14.4. Where all of a sudden, 1, 2, 3, 4, 5, 6 lines down, it says at the public hearing. And I believe what the hearings that are being referred to in this section, these sections are what many towns refer to as show cause hearings. And it's the type of thing where the agent has to issue these folks this letter 10 days prior to a meeting at which a show cause hearing will be held in order for them to come in and say why they believe the order to cease and desist or correct violations should be withdrawn or rescinded. And it's not, they're not public hearings that get run, two legal notices and one following.
Right.
So that, I just think that word public hearing in 14.4, the public hearing should be deleted.
Marla, that's being, so you're suggesting delete just public? You're not suggesting that it be replaced with show cause? At a show cause hearing
I didn't, this is Margaret, I didn't see show cause in here.
at all?
Right,
At a hearing to show cause, yeah.
I mean-
Because it does say later to show that compliance with its license. So correct, I believe, Margaret, you are correct that that probably should not be public. Listed because it technically is not a public hearing, just like the hearing that is held on an order issued is not technically a public hearing. It's the public doesn't get to weigh in on it.
and this is Margaret, if you wanted to refer to the hearings in section 14.3A and 14.4 with the words show cause, it may help people understand that it's not a public hearing. So however you want to do it would be fine. And that's the end of my comments and questions.
Can I clarify where you're talking about adding the term show cause? Line 1, 2, 3, 4, 5, 6 lines down on paragraph A. It says, it starts with the facts presented at the hearing,
Actually, it's one, two,
Also on line
fourth
4.
sentence.
a hearing, line
Yeah, a
4, yeah.
hearing. A show cause hearing could, it could
So
say.
add the words show cause in front of the word hearing. That's what you're suggesting?
Right, and then on line 6, the words, the hearing shows up, show up twice.
Mhm.
It would just help folks understand that it's not a public hearing, which has different requirements.
I would have no objection to those additional changes.
Thank you.
I love that speaking.
Margaret, does that
Concludes
include
my
comments at
my
this time?
comments and questions.
Well, the
and I-
commission is very grateful for your eye for detail. And I think those are very helpful comments. Thank you. Commissioner Ober.
Yes, would it be appropriate for us to include a glossary on this? There were several terms that came up that may not all be familiar to the public and I looked for one when Ms. Washburn asked some questions of me.
This is Commissioner O'Neill.
Yeah, Commissioner George O'Neill, we do have a section on definitions. I wonder if
Okay.
it begs the question as to how much you can incorporate of the English language, which is voluminous. But I get your point. Hopefully those individuals involved with this might gather it and seek guidance from the agent to clarify, but we do have a whole section in there already.
But she brings up a good point, and that is, we've been poking around on this for a while. It said 2009, but I guarantee you, we did not do the entire process. This is the time to try to get it right for the next 10 years. And as much as we can do to make it a transparent and smooth flowing process, we should do.
I believe, this is Margaret, I believe the term show cause hearing is in the statute. That's where it came from,
Mhm.
so.
It's in
The
regulations.
statute's also a place where folks can go for trying to understand the terms.
This is Chairman Dustin. My sense was that from paragraph 14.4, the context clarifies what could be meant by show cause hearing. Yeah. Thank you.
Welcome.
Could I have the sign up list, please?
Yes, I believe now is a time to pause for a moment to give any members of the public who wish to speak in person an opportunity to place their names on the list, and we do have a number of names here. So the commission will now receive in-person testimony. As I call your name, please rise if you choose, or in any case, clearly state your name and address for the record. There is a 5-minute time limit for testimony and comments, with the opportunity for an additional 3 minutes after everyone who wishes to speak, including those attending via Zoom, has had the opportunity to do so once. With that, I'll recognize the first speaker, Diane Jameson.
My name is Diana Jameson. I live at 490 Sunset Hill Road in North Grovenordale, Connecticut. I want to start by thanking all of you for your service. It's very impressive to sit here, and it's also nice to be able to laugh at a meeting like this, because I like your kind of, you know, fun with each other.
Irreverence.
That's it. I don't have the patience, or maybe not even the mental acuity anymore, to be able to go into this kind of detail. I wouldn't have a lot of patience with it, so I appreciate that there are people who do and spend the time. I'm very serious about that. I have to admit, I didn't do my homework. I did not read the 100 pages, I think that it was, that I was going to supposedly print out, nor did I come and look at it. But I did kind of read what the overall view of the purpose for tonight. And I guess the reason I'm here is just to advocate for wetlands. I served on the original Open Space Planning Commission with Carolyn Wurge, and I learned an awful lot from that woman. She's also a neighbor of mine, as is Diane. We have a lot of wetlands in common, you know. So, I mean, it's just important. And I mean, I think you all know that. I just feel like I wanted to come because with the pressures of industry or fossil fuel activities, or just people who want, you know, they want to do what they want to do with their land, it's really easy to look at a vernal pool or swamp and say, well, that's not that important. But what I learned from Carolyn is it is that important. And if we start filling them in or covering them up or not taking care of them, we're just contributing to more problems with our climate and with our survival. So that's really what I'm here to say.
Thank you.
Thanks.
The next name on the list is Roman Jameson.
Wow, Ramon Jameson, 56 Taylor Road, in the aquatic section of town, I guess you call it. Wow, I'm unprepared. I obviously should have been coming to your meetings for the last 5 years or something. And I missed, I think you said 3 times this was announced somewhere. I didn't see any of those. I only saw the most recent, well, 2 weeks ago, public hearing notice. So, I guess, yeah, and thanks, you're doing, yeah, a lot of work. So in the back of my mind, within the last couple of years, I believe the Supreme Court ruled that wetlands and swamps that were not connected to larger body of water were no longer protected under some, you know, which would just, it was terrible, sounded terrible to me. So I guess that's partly, I assume we're going to continue trying to protect wetlands as much as we can. I have a lot of it on my 18 acres, and it just sits there. You know, I get to hear the peepers and I get to slap the mosquitoes. Thinking about that Supreme Court ruling, does that mean I could fill it all in and sell it to Walmart? I don't know, but which is nothing I ever want to do. But just saying, yeah. So I don't know, I don't even know what the old regulations were. Although, well, actually, years and years ago, when I first moved down to that property, I noticed that people had been piling stuff into the, off the bank, off the dry land into the wet, you know, shingles and leaves. And so I asked Thelma Barker years ago, and she said, oh no, you shouldn't dump anything in there, not even leaves. So that was what I've kind of remembered. So, and, you know, I see people doing it, so I don't know, but maybe those, I don't know how big, you know, wetlands, how much acreage does it have to be, or is it just a little wet place that people tend to just pile their logs into or whatever? So I just would like us to really protect those important things that are way more important than Walmarts and gas stations and stuff. Thank you.
Thank you, Mr. Jameson. Commission applauds your conscientiousness. Are there any attendees
Just
waiting in the
Cindy,
Zoom room to speak?
our zoning enforcement officer.
Mhm.
That's the only person on Zoom.
She waved. She has her hand up.
She has her hand up. So,
I don't have,
She didn't have her hand.
Oh,
It's a cursor?
it's on off.
oh.
That's, yeah, that was the.
It's a weird.
It's a false hand.
Okay,
Is-
I don't have any comments. It's just interesting to listen to this process. So that's why I'm listening to it.
Thanks, Cindy.
Okay, thank you, Cindy, for joining us. I was going to ask if there's anyone else who wishes to speak who has not already done so, but I think everyone in the room has been given an opportunity to speak, and unless they'd like a further opportunity. If not, Ms. Butts, do you have any further comments or testimony? to
yes.
offer?
First I had an omission, which Janet Blanchette had asked that her memo be read into the record. That's dated May 21st to the Thompson and the Wetlands Commission from Janet Blanchette with a copy to Margaret Washburn and Tira and Giesick regarding proposed revisions to the Thompson Wetlands regulations. She writes, "Thank you for working diligently on updating the regulations. We just recently were made aware that the regulations were ready for public comment, and when the public hearing notice appeared on the town's website. Unfortunately, I cannot attend the hearing on Wednesday, 5/22, and hope that you will consider holding the hearing open for another month to give more time for interested parties to review and comment upon changes. I hope you will consider contacting local soil scientists, planners, surveyors, and engineers of the proposed changes to solicit comments. These professionals can provide valuable feedback since they understand the practical application of the regulations. It is common practice in many towns to reach out in this manner. If you do not have a list readily available, I suggest contacting NECOG planner Delia Fay. She regularly sends out notices of regulation updates to local land use professionals." The next thing that I would like to go through is the comments that I have on Kira's comments. So I would offer this as an exhibit. Give it to Margaret.
I have mine.
You have my comments?
Oh,
No,
no, I'm
well,
sorry,
you want
I have the
copy of
one
mine?
that Kira
Come on.
wrote on, sorry.
All right.
Kate.
So let me know, you have copies of the Tira's annotated notes?
Yes.
Do you want them on screen share, or do you think you can work from your hard copy? What is your,
I can work from the hard copy.
Well, I can work from the hard copy, but there's only Cindy is the only member of the public that's up there.
I have a laptop here that has it up, I can screen share. And as I move through my comments, I can go through page by page when I get, if that is of assistance to you.
I maybe due diligence to do that if it's not onerous. We have our bases covered.
Yes. Is that exhibit 12? Yes. That's the next exhibit. So I guess I have to screen share.
Yeah, you've been given.
Oh, I have?
Yeah.
So how do I gotta go back to Zoom, hold on, share screen,
Yep. And then you'll choose whichever.
which one I want.
Right. And then I think at the bottom it might say.
Select, no, just this one. I can't share.
Did you get it?
Yeah.
Okay. There
See
you
if
go.
it comes up. There you got it. Okay.
Thank you.
I'll wait till George comes back. If that's okay.
Yes,
If you wouldn't mind putting a pause, I use the ladies' room.
that's probably a good idea. Why don't we take a 5-minute recess? That's a good call. We'll reconvene at 8:22. Mistaken.
Have you ever been to their brewery, the Long Trail Brewery?
No, I've not been to the brewery, but I've driven past it.
It's nice.
Is it?
Good hamburgers.
Really?
It's something to happen.
We finished the meeting. Right?
Teach me to get coffee before I go to bed.
He's okay on the trail, but he'll outside of my house.
Oh, great.
Happy guys, my name, it's the same good way was I go out and do. So my home's down today. He was.
Yeah, it's open.
What just bit me while I was doing this. But they're fine. But all your end good. Yeah. Yeah, so.
Marla requested it.
Yeah, it's the best.
Oh, great.
So we're
I didn't miss any much.
in recess
I could
No,
have.
we stopped.
for 3 minutes.
You walked
We
out of
had
the,
commission,
you
quorum.
walked out of the room, we said, okay, George is buying the first round, and then we took a break.
That will come.
Right now, I'm working and I said.
Oh.
So we can do that, you better call her back, and so I went with her.
We're gonna get summer weather
So
going
I
forward.
hope, you know, hope the
Hmm?
couple
We'll have summer weather going forward.
Sounds like it.
And
Looks
it
like
was-
it.
Yeah.
She's so good, she's so good. I said, that's, she's a lab. But, you know, I think it's good for her, it's a female and not a male. Yeah. It's not a shepherd that she had because. Yeah, you know, other than this, it keeps on.
Thompson could use a brewery. We have all
We have a new one, don't we? We have a new one.
In Thompson.
Yeah, Main Street.
Triple Raven.
Yes, it's called
Okay, why have I not heard it?
Three Ravens.
Three Ravens.
And they opened
That's
up
an
on-
old song.
A week ago.
Goes back to the Middle Ages.
Yes.
You like
Oh, the Ravens were,
Three Ravens.
UK, they have ravens.
Kind of a grizzly.
It's bigger than Cardiff.
yes, they are. There was a pair of ravens nesting at the power, I guess it's a
Oh, West
turbine
Thompson, yeah.
generator on the West
They're
Thompson
there,
Dam.
there again this year. You can see
Are
their
they
nest.
still? I haven't
So their
seen.
nest is clearly visible from the road. If you pull in where the, whatever you call that structure. is,
Yeah.
Yeah, off the bridge, you can see they're underneath the kind of, it's not really a drawbridge. It looks like a drawbridge that goes over to
Yeah.
the, where you go down into the, and you can
Can't
see
walk
them,
almost,
they're,
yeah.
they're underneath there.
Yeah,
They've been there for
remember-
several years.
I haven't seen them lately, but
They're
they were
there.
They were there.
They visit my house.
I remember in my ornithology class, Dr. Wright, this is in Montana, he says, you know the difference between the flight of a raven and the flight of a crow? And Neil said, no, he says, a crow goes like this.
Right, it's in the wing beam. That's right.
And he said, a raven goes like this.
Have you been to the brewery? Yeah,
Yes, there's a new,
yeah, over up the street, yeah.
yeah,
Yeah.
I haven't been in it yet.
Oh,
but,
I wondered who had been there.
Yeah, we have targets.
Oh, I keep meaning to go over there. It just opened. I have to go over and check it
How
out.
late is it open?
I think we should.
Better than us. No,
I moved to adjourn.
no.
Across the street.
Right by the church, at the end of Main Street.
Really?
Yeah,
They're not,
that's commercial
they're not
space.
dumping stuff in the river, are they?
There, since I moved into Thompson, there have been 3 other businesses that have tried that spot.
Uh-huh.
But they had
Two
their
bakeries and a
own model.
restaurant.
There, you know, if and whenever we get that, and we're putting a lot of eggs in that basket. But if and whenever that mill is refurbished and occupied,
Yeah,
Then a restaurant with daytime clientele would make more sense. But the breakfast and lunch kind of thing, they couldn't seem to attract enough people over there. But we're on Route 12.
Thank you very much for coming. We appreciate your comments.
Good night.
Thank you.
If it were on Route 12, it would,
Location.
location and timing.
This hearing will reconvene at 8:23 p.m.
Is it being recorded?
It's
What
not
time?
being recorded. I didn't stop.
Uh-oh.
Marla Butt speaking. So first, I have handed out to you and offered as an exhibit my comments to my response to Tara Penke's comments for this hearing. I have some global comments regarding wetlands agent. Tara comments that the reference to wetlands agent should be replaced with wetlands officer, reasoning that the position is an officer with enforcement authority. The term agent is the one that's used in the statute and the DEP model regulation. The town may employ an individual with the title of wetlands officer or wetlands enforcement officer for that matter, and the commission may authorize that individual employed as the wetlands officer or wetlands enforcement officer to act as its agent to process licenses for work in the upland review area and initiate enforcement actions, among other things. A review of other municipal websites and associated inland wetlands regulations reveals that while the regulations to cite agent, designated agent, or duly authorized agent, that the agent is frequently has a different employment title, like land use agent, zoning enforcement officer, wetlands enforcement officer. Next, in the definition of wetlands agent, let's go on the screen to look at the definition of wetlands agent. Sorry for the scroll number. Here has commented that the agent should be an individual employed by the town. I do not agree. The commission may find the need to authorize a member of the commission to act as its agent, and Tira's proposed language change would prohibit that. This is of particular concern if the commission or its chair finds that a condition that warrants an enforcement action and the agent is either unwilling or unable to initiate that action. Note, an agent may find him or herself in need to recuse from taking an action due to a potential conflict of interest warranting the appointment of another individual to act as the wetlands agent. I recommend keeping the proposed language for wetlands agent. The next issue is state versus town reference. This, I'll go back up to section 1, because that's where it starts. Is there a way I can get rid of my, oh, you don't see it, I see it, it's covering part of my screen. How do I get rid of that? Don't let me else see it's covering part of my screen.
Click.
Yeah,
Well, actually, this one right here.
this one,
Nope, yeah,
that's it.
that works
That's
too.
it. Okay. Tara has commented replacing the word state with town in numerous places. I recommend keeping the original language. First, in section 1.1 of the language contained therein is a repeat of the public policy. Let's see where the town, where she keeps repeating the town. Is a repeat of the public policy enacted by the state legislature in section 22-836 of the Connecticut General Statutes. Wetlands and watercourses do not exist in Thompson in isolation. What happens in Thompson's wetlands and watercourses can affect adjoining towns, as well as other parts of downstream waters and vice versa. While several other inland wetlands agencies in the state have chosen to replace the word state with town in this section, the majority have not. I recommend no change to the proposed language here or anywhere the suggestion is made to replace state with town, such as in waters of the state. She has suggested waters of the town. That is referenced in some of the definitions. The third issue that I have globally is the capitalization of the term "these regulations." And if I can go down. Section 1.2 is where it first starts. Tira has commented on capitalizing these regulations throughout the proposed regulation revisions. You should note that while the Thompson subdivision regulations capitalize the term "these regulations," the Thompson zoning regulations found in Thompson's Code of Ordinances do not. I'm assuming the zoning regulations were vetted by a professional editor. I have no opinion on this. The commission can take whatever choice they want, and it's appropriate as far as I'm concerned. Then they go to specific comments not globally referenced. First one is on section 3.1. Here has commented at the end of the section, adding language that conditions the initiation of enforcement action for regulated activities in wetlands and watercourses only if such wetlands and watercourses have been verified by a qualified soil scientist. I recommend keeping the proposed language without revision. Please refer to the comments in the red line copy for discussion. You have a copy of the red line version. The proposed language was vetted and revised by Attorney Slater. Note that the delineation of watercourses that includes swamps, marshes, and bogs does not require the services of a qualified soil scientist. I suggest that you see section 7.5 K6 of the proposed regulations. That's where it talks about watercourses, delineation of watercourses. She also makes comments on section 3.2 and 3.3, and I have no opinion about the language changes she's asking for, except for the global ones that I've already talked about. Next item was section 4.1b. 4.1b. I've got it on the screen for you if you need it. The proposed language is the same as that in section 22A 40-parenthetical A, parenthetical 2 of the Connecticut General Statutes. Tira comments, municipal planning and zoning commission should be replaced with, quote, planning and zoning commission of the town, in parentheses, hereafter PZC, end of quote. I have no objection to such a replacement, but then there will be a need to change the language, language changes for planning and zoning commission references in sections 10.1, 8.2, and 11.5, and replace it with PCC. Section 4.1F. The proposed language is the same as that in section 22A40, parenthetical A, parenthetical 2 of the Connecticut General Statutes. Kira questions the word subdivision meaning subsection. I have no objection to the language change. Section 4.4.
Commissioner Herbert.
Yes, question.
Yeah.
This uses the word subdivision, meaning subsection, but a subsection of this ordinance is different than a subdivision. When I'm thinking of somebody wants to divide their property. So if that language is what she's saying is confusing, I agree.
That's why I have no objection to the change. Section 4.4, Tira comments questioning the logic of the section and doesn't understand why the agent can't render decision on uses permitted as of right and non-regulated uses. First, the statute requires such decisions are a requirement for the commission and does not provide for the delegation of its authority when the activity is in wetlands and watercourses. The statute makes no reference to upland review areas or regulated activities in upland review areas. The proposed draft language adds language for wetlands agent to authorize jurisdictional rulings for regulated activities in the upland review area without review or appeal to the commission. This language was reviewed and vetted by Attorney Slater. I recommend no changes to the proposed language. Sections.
Can I, excuse me, Margaret?
I'm gonna call it a night.
All
Thank
right.
you. I trust it's all in good hands, and thanks for all your work on this, everybody.
Thank you
Sorry
very
to
much.
interrupt.
Thank you very much for joining
Good
us.
night.
Thank you
I'm
again
glad
for your
to-
comments.
I'm glad that you're joining us.
Thank you.
We all are.
Appreciate it.
We'll see you again before you know.
Next section is 6.4. I have it up on the screen. Tira comments to replace, quote, "the conditions must be strictly adhered to," with, quote, "failure to adhere to such conditions shall result in enforcement action," end of quote. I do not recommend such language change. First, it mandates an enforcement action and does not allow for handling the failure to adhere to conditions in other ways. Sometimes a licensee is unaware of noncompliance issues and once made aware, corrects the noncompliance without the need for issuing a notice of violation or other enforcement action. This is frequently done verbally and sometimes followed up with a written communication confirming the compliance issue and its correction. Second, failures to comply with the regulations, including 6.4, are addressed in section 14, which is the enforcement section. Section 7.1. Tier comments to remove the words summarily rejected and in parentheses, some quote, summarily rejected and end of quote, be deleted and add without prejudice, in quotes, later. Please see the red line comments for this section. The proposed language was reviewed and discussed with Attorney Slater. The term without prejudice is a legal term and its implications are unclear. I recommend no changes to the proposed language. Section 7.2. Tara comments to remove the repetitive reference to site plan approval, special permit subdivision, and re-subdivision. I recommend accepting the proposed changes. Note sections 8-3C, 8-3G1, and 8-70A of the Connecticut General Statutes specifically reference inland wetlands corridor course application submission requirements for PZC application sites containing inland wetlands and water courses. Section 7.3. Tara questions if this section is redundant to section 7.5. I have no recommendation on that. It's just a question. 7.4. Tara comments that the officer, i.e. the wetlands agent, should be able to determine if the proposed application involves a significant activity as part of a pre-application meeting. We've already discussed this briefly, but I oppose the change to this language as it is the responsibility of the commission to determine what is a significant activity. The statute does not delegate this responsibility to any agent. There is nothing preventing an applicant from reviewing the application with the commission's agent or the applicant to get a feel for what the commission might be concerned about, and the commission may make its determination based upon its agent's input. Section 7.5. Tara comments are not substantive. I recommend no change in the language. That's my opinion. 7.5. So for example, in G, she suggests changing description and reversing it with purpose. And rewriting the way B is written. I have no opinion about, make no recommendation about this, her suggested changes. Next item is 7.6. Tara asks, is a jurisdictional ruling not a precursor to an application? And are you requiring as of right activities to show all paperwork of a permit application up front? Answer. A jurisdictional ruling is not necessarily a precursor to a jurisdictional ruling, but it can be should the commission decide to deny the application for a use permitted as of right or a non-regulated use. Section 7.5 provides the minimum information needed for an application involving either a jurisdictional ruling, a wetlands agent approval, or an individual permit. Section 7.6 provides for additional information only on jurisdictional rulings.
Marla, this is Chairman Dustin. May I ask the second sentence there? A jurisdictional ruling is not necessarily a precursor to a jurisdictional ruling, but it can be. Can you briefly explain what that means?
Oh, that's the
An
wrong word.
application?
It should have said precursor to a permit
Okay.
application. Permit application, excuse me, that's, I can't call it a Scrivener's error, it's senior moment.
Understand, thank you.
Section 7.7. Tira asks 3 questions in 7.7. Down here. She asks 1, how can you ask for information on alternatives up front? Answer, Section 22A42J of the Connecticut General Statutes requires the commission to use the factors for considerations provided in Section 22A41 of the statutes in its regulations. Section 22A41, parenthetical A, parenthetical 2 of the statutes requires the commission consider the applicant's purpose for and any feasible and prudent alternatives to the proposed regulated activity, which alternatives would cause less or no environmental impact to the wetlands or watercourses. Second question, why is it assumed that the applicant has chosen a optimal action? Answer, what is an optimal action for the applicant may not be the optimal action for the wetlands and watercourses. Alternatives may exist that meet the applicant's purpose, but involve different actions from that applied for. Requesting the applicant to identify what alternatives the applicant investigated did not choose is appropriate. Question 3. Shouldn't it be the officer, i.e. the wetlands agent, or the commission who identifies and suggests or requires an alternate plan? Answer, the burden of proof regarding availability or lack thereof of an alternative lies with the applicant. The commission may ask why a particular alternative is not viable, but is not the same as suggesting an alternative. There may be an instance when the commission is denying an application based on the existence of an alternative. Well, that looks like there may be an instant when the commission is denying an application based on the existence of an alternative on the basis the commission would be obligated to identify the possible alternative or alternatives the applicant has failed to show were not feasible or prudent. I can see that there's a problem with that sentence, but I think you get the idea. We do. I recommend no changes to 7.7. Section 7.8. Tira suggests the officer, that is the wetlands agent, determine if a proposed activity is significant. This is the commission's responsibility. See my comments on section 7.4. I recommend no change to the posted language. Section 7.10A. Tira comments that it is a run-on sentence, is hard to follow, and it should be broken up into clearer, shorter sentences. She does not offer suggested edits. I agree the sentence. I agree it is a long sentence identifying a requirement with a limitation and an exception. However, the language echoes the requirements of section 47-42D, parenthetical B of the statutes, is accurate and has been reviewed by Attorney Slater without request for modification. I recommend no change in the posted language. Section 8.1. Here are comments that the language relating to the town clerk's actions. I recommend no change in the posted language. Section 8.6. Tira questions if the word open should be available. Either is acceptable. I have no recommendation. Section 9.1. I think we've already talked about this. Tira questions why the phrase "the commission shall not hold a public hearing unless" is phrased in the negative, and shouldn't it be "the commission shall hold a hearing if any of the following apply"? The drafted language is found in section 22A, 42A, parenthetical C, parenthetical 1 of the statutes. Tira's suggested language would not prohibit the holding of a public hearing, and in doing so could cause a violation of statute. Tira has suggested other changes that appear to be wordsmithing. I recommend no change in the posted language. Section 9.2. Tira suggests adding the word without prejudice. Again, the term without prejudice is a legal term and its implications are unclear. I recommend no change to the posted language. Section 10. Tira suggests language and structure changes. I recommend no changes to the posted language except to replace the Northeast Regional Planning Agency with Northeast Connecticut Council of Governments.
Okay.
Section 10(2)E. Tira comments that the term character is a term that is discouraged in zoning regulation and recommends a more precise synonym. The language here comes from section 22A-41 of the statutes. I recommend no changes to the posted language. It is the exact language in the statutes that's given here. Section 10.6. Tara comments that the section is not clear. It is the same language found in section 22A-41 parenthetical D of the statutes. I recommend no change to the posted language. 10.8. Tara suggests replacing shall not grant with shall deny. This language was reviewed by Attorney Slater and had no comment on it. Because not granting may not be the same thing as denying, I recommend no changes to the posted language. Section 11.1. Tira questions the use of the term grant instead of approve. This language was reviewed by Attorney Slater and had no comment on it. I recommend no changes to the posted language. Section 13.3A. And I believe we already talked about this. Tara
did,
commented
yeah.
that the first section doesn't make sense to her. This language was reviewed by Attorney Slater and edited by him based on litigation he was involved with. I suggest Tara contact him regarding his reasoning for the language. I recommend no changes to the posted language. And that was the last of my comments. I believe there's nothing else in there.
Marla, could we look at 13.3 while you're there or we're there?
13.3A.
It's
Already long.
If the second sentence
Acceptable financial.
is not a complete sentence, so I'm wondering if that originally was meant to be one long
It was,
sentence.
it's a typo. Financial dot A, just remove that and it's a complete sentence.
Remove what?
The word financial, the period, and the capital A.
Acceptable
Exactly.
financial.
Exactly. I think
guarantee
it's
issued
a
by
Scrivener's error. It's a.
Right, it should be an acceptable
Commissioner
financial
O'Neill, yeah.
guarantee issued by a company licensed.
Yes.
Just an oversight. Then you have a complete sentence. It's
Yeah.
just somehow that,
And that's much clearer.
Got missed.
just
Yeah.
the the attorney missed it, everybody missed it.
Those are true.
I could have been my error in
Somewhere it got dropped, yeah, it's a complete sentence now.
Okay, thank you.
I was gonna make that same exact recommendation.
Commissioner Ober.
Yes, couple of observations regarding these notes. First of all, those of us that have been involved in this process for a while know that a lot of it was to match the language between the state and our ordinance and to synchronize language between our ordinance and other land use agencies within the town. The first item here, bullet point says wetland agent, and Ms. Washburn had a suggestion on that. What is it that we're deciding? We're going to use the term wetlands enforcement officer? Or not?
Can I step in, Commissioner Obert? And the next item on the agenda for the special meeting is precisely what you are starting us off on. Before we go there, I would ordinarily at this point entertain a motion to close the public hearing, which is still open. And we do have before us some citizens' comments requesting a continuation. So I want to be sure that the consensus of the commission is that the public hearing has done its work, and we are prepared to close that hearing, unless there are some other views on this.
I'll make the motion that we close the public hearing.
I'll second the motion.
Second that. All those in favor?
Aye.
All those opposed? Yeah, the public hearing is closed.
Okay.
Thank you. So now we can proceed to the next item on the agenda, which is the discussion and follow-up action by the commission on the proposed regulation revisions. And my proposal is that we go through these comments, and the comments we have before us are Margaret's comments, some of which were addressed in, I think, in conversation, but we want to make sure we have the final language right. And then Tira's comments, which Marla has done a wonderful job attentively going through. So at this point, and then I will, when we've sufficiently discussed each of those areas of concern, I will entertain a series of motions to ensure that we are approving everything that we need to approve, and we know how things stand. Commissioner Obert.
Okay, Margaret Washburn said that she had a preference in the terminology. I believe it was wetlands enforcement officer. And if that's correct, based on her suggestion, unless we can find some reason not to do it, then I believe that we should.
It's Commissioner Chapin. I believe that what Marla had pointed out was the regulations refer to the person, the title as the wetlands agent. The town may choose to give her an employment, but the term used should be agent in the regulations. And they can call her on her business card. She can say that she's the wetlands enforcement officer, be paid like that, be employed like that. But the term of her role, according to be in consensus with the regulations of the state, should be wetlands agent.
May I add to Commissioner Chapin's comments? You bring up an excellent point, Commissioner Obert, that we sometimes get trapped into this. What is the definition? When the concept of agency is what we're talking about, agent, who's an agent, which has tons of legal implications,
Correct.
which is broader. And I think Marla clarified that point. So it's not, we're actually succeeding in achieving her goal, that goal, and actually not limiting it by putting it saying enforcement. All of a sudden you've defined it. In a couple of cases, we look here when we say, well, let's remove that. No. When you either make it more precise, exclude it by exclusion, and then bring it back in. So yes, I think that's we keep it as it is.
And
Okay.
this is Amy St. Ange. Just want to point out that under her contract, she is the officer.
Yeah.
So.
Chairman Dustin, I am partial to the idea of having an enforcement officer, because that makes the idea of enforcement real. But I also agree with Commissioner O'Neill that an agent is, at least philosophically, someone who acts on behalf
Yes.
of a body, and that may include more than just
Yeah,
enforcement.
exactly.
And it is not exclusively enforcement.
Yeah, exactly.
Okay.
And it is not exclusively employed by the town. In the case where we get onto if somebody, she has to have somebody, she has to recuse herself, or she has to have somebody act on her behalf because of some reason, that would be an agent.
Okay.
So are we agreeing that we're leaving
Win-win
that
there.
as
If we look at
language
loss.
stays as
That's
agent?
right. It also, this is Chairman Dustin, I'm getting ahead of us in a way, but it relates to the reason why the question of whether the agent has to be an employee of the town is that we might want to duly authorize someone else
Right,
to
right.
act on our behalf.
So what are you consenting to?
That the language stays in the regulations as agent. The reference is to agent, not to officer or enforcement officer.
Thank you.
So as Chairman Dustin, I'm correct, we're working through Margaret Washburn's comments, some of which have been addressed, and then I
Right.
propose that we turn to Tira's
Okay,
oops list. I did note, Chairman Dustin, again, page 12 of 7.4. That was the question about a pre-application meeting. And it struck me that you could add the phrase "with the commission." Margaret was unclear as to whether that was a pre-application meeting with the agent or with the commission, if you wanted to be more precise, so perhaps you're comfortable with the language as it's stated.
Marla, she was asking why the agent wasn't the one making that determination.
Right,
Because that's what Tira had suggested.
right.
Commissioner O'Neill, and I would also observe that a number of the comments were more rhetorical and for clarification as opposed to change. That Margaret Washburn says, please clarify. She didn't say, I'm going to change it. I just want to better understand. So the necessity, there's only one or two items that really she says, I recommend something different.
Other items on.
The comments that were raised by Tira Penn.
We're still on.
Yeah.
We're still on
Margaret.
Washburn.
Yes.
Washburn.
Yeah, I don't have all. I read all.
13.3, which I think you already addressed. I mean, all the prior between the first, and I've noted each one of about 8 or 9. All those were more clarifications, not requesting changes or indifference. The one specific item, which was, I believe, correct, that was 13.3 sub A regarding the the complete sentence, which was a Scribner's error, which should be corrected. So that I think it should be adopted.
Yeah.
Otherwise,
Mr. Chairman Dustin, I did note on page 18, 8.6, you seemed agreeable to change open to available.
What page again?
That's page
18.
18, 8.6.
I think they both brought that up.
Yes, that was.
Change that to available.
Page open to available. That was on Tira's list as
Right.
well. No,
Mhm.
that was all I had.
And on Marla, but speaking on page 25,
Mhm.
13.3A, the Scribner's error that you say is to delete the first financial period, capital A. And so that it reads, if in the form of an acceptable financial guarantee issued by a company licensed.
Exactly.
Okay.
Are we ready to turn to Tira's comments and
yes.
Marla's response to those?
From the comments from Tira.
From her.
Do we want to go through
Yeah.
it paragraph by
would go-
paragraph? Because
I propose we go paragraph to paragraph. I was, we can do a couple of things. We can act on Marla's recommendation to change or not to change. On some of these items, she has no opinion.
Yep.
Chair, Commissioner O'Neill, I recommend we do it by exception, where she recommends no change. I recommend that we adopt no change, and where she has no opinion, then we should look at those 2 or 3 items, and say, okay, is it necessary or not, or leave it as it is? That will.
I like that
accelerate our
too.
review.
I
agree
think there's
with
only
that
like
procedure.
4.
Yeah, exactly. Let's
You
look
know,
at those.
exceptions.
Okay. So the first, from what I can tell, was the capitalization of these regulations.
Correct.
I like capitals, but Commissioner O'Neill. I can never get it right, though.
I want to hear from the English teacher on this.
Okay.
That can go either way. This should be more academic and statutory. I can understand why capitalizing, because it's like Catholic with a small c and Catholic with a big C. It's, if you're referring specifically to these regulations, that would be capitalized. If you're referring to regulations,
So what do you recommend?
change it to a capital.
Oh, good.
That's just a global search and
not-
replace.
Yeah.
That's not.
Right.
Okay.
Marla, what page are we on?
This starts on page 1. 1.2 is the first place where Tira suggests changing the language lowercase regulations to uppercase regulations for these regulations. 1.2.
That
Last,
should be easy.
capitalize the R in these regulations in quotes.
Find and replace.
Right.
Yes.
Hopefully there's no reference.
And
to
that will be a
local
global search
regulations
and
of the
replace.
government.
Well, you gotta look.
The next item was section 3.2 and 3.3, where there was no opinion on the language change.
Wait a minute.
You missed one in section 1.1,
Okay,
changing the reference to state. Replacing this is.
No, we're
global.
going with
No,
yours.
it's-
Yep.
We're going with your recommendation.
Yeah,
where
we
you
went, we
made a
accepted all yours.
Oh.
We just
Yeah.
went by
Yes.
accept,
Oh,
Yeah.
okay, all right.
Yeah.
where you had no.
Okay, all right,
recommendation.
okay,
that's all.
all right,
Yeah, we went on the fast track, that anything you recommended,
okay,
we'd go with.
okay. And this is.
We-
So the next one I have a question on is 4.1F.
Oh, I have
Was it-
4.1B. I think she wanted
The,
different language, and I don't think it adds anything, but. You know,
I'll put it up on the screen if you want. 4.1.
I mean, it's going from a more generic to a more Thompson.
Yeah,
Um,
4.1B. Oh,
and it
Yeah,
makes more
4.1B,
work, because then you have to
yeah.
change it in other places, so. If it were me, I'd be like, no, but, you know.
This is-
I'm like, I don't think it adds any value, you
Right.
know, to make that change. I mean, I think anybody could come in and read them and say, well, no, you should use this word here, or, well, we didn't, you
there's a
know,
distinction without a difference.
correct.
The materiality seems to
Yeah.
be lost here.
I like that phrase.
I agree.
think
That's
we're
a-
gonna
that's a-
use it.
They use
Take
it in
it.
philosophy a lot too.
Okay, so we're on to
4.1F.
Yes, and we're going to,
Well, this is subdivision to subsection.
we're going to call it subsection, not subdivision.
I would agree with that.
great, let's do it.
Okay,
Everybody clear?
Where's the other
I
exception?
wanna look at it in the thing, hold on.
7.3, the next one that has no comment?
I have a
Well,
question about
7.2, Marla actually agrees with Tira.
6.4.
Ah, okay.
I want us to make sure that the word sometimes is not, is striped sometimes, it should be always. We should always follow up with written communication.
For sure.
That's our evidence that we notified the resident of the town.
So you're objecting to the recommendation of our agent, Marla, that she didn't recommend a change, or you're just affirming her recommendation to make that
Well,
change?
this says, this is frequently done, I'm looking at 1, 2, 3, 4, 5, in the 6th line down, it says. This is frequently done verbally and sometimes followed up with a written communication. I want to strike sometimes.
That's not in the
Yeah,
regulation.
That's not a regulation.
That, that's only.
Right, this
Marla's
is just an
comment.
explanation
Yeah, that's,
of
this is
the
like,
language.
this is clarification. This is
Yeah.
rhetorical response to a question. It giving
Okay,
context.
then
to it.
I got,
So there's no
I got
change.
myself unnecessarily confused. I thought
Correct.
that she
Yeah.
was suggesting that as a.
No.
No, it's
No.
not practice.
We can move, I think 7.3 is.
I've
what-
been wrong before.
No worries.
Well, 7.2.
Okay.
You want to,
You recommended the
Marla
change. I thought we were gonna
recommended
accept her changes though.
Oh, yes, but.
So we're gonna, when she objected, we're gonna keep the objection. When she accepted, we accepted. So now we're talking about the delta.
You're right.
So I've got 7.2 on the screen,
Mhm.
so
Just to
it would
be
be
clear.
deleting what she's got deleted there.
Yeah,
Right, and
we accepted your
we're okay,
recommendations.
right.
We accepted your recommendations. We're just looking at those where you have no comment.
Mhm.
We're looking at the.
Gloria, you.
Like
can-
7.3.
But I have to know what I have to change in the regs
Yeah.
to give you the final wording, and I want to make sure I get it right, so we don't have wrong. Okay,
So 7.1, there's no changes.
yeah,
In the third line.
7.2, knock out this second site plan approval, special permit.
You recommend accepting the proposed changes.
Yeah.
We're at 7.2.
Which deletes site plan approval, comma, special permit, or, and adds the word the,
Yeah, the applicant, yeah,
yep. And then knocks out,
for the subdivision or re-subdivision at the end.
So for the subdivision and re-subdivision gets deleted.
Yeah, but it says she added, I think that says, I think that says with the planning and
Yes.
zoning commission. I think that's what that note in the end is.
I'll-
So the
okay.
application is filed with
Oh, yeah,
the
I didn't-
planning and zoning commission.
With
It's up on this.
the planning and zoning commission.
Okay,
Tricky.
yes.
Do you want that Thompson Planning and Zoning Commission or just Planning and Zoning Commission?
I
Let
don't
me
think you
see.
need to repeat Thompson.
Yeah.
Thompson
Keep saying it.
in the first.
Yeah, but I don't.
Thompson's regs, we know it already.
If it's in the. No, it's not in the definition, so it's okay. Okay,
Okay, 7.3.
What's 7.3?
Well, this is the redundancy.
Is this not redundant? It's a rhetorical question that she posed.
Honestly, I don't care if it's redundant. I'd rather have it in there
redundancy is a good
twice,
thing
right?
In ecosystems.
Yeah.
So I think it can be all.
Leave it.
It's good in
regulations, too.
electrical systems,
retain
too,
that.
communication systems.
Where's the one that we have?
Okay.
47576.
The next one I have is 7.6, but I don't know if anybody else has.
Is that merely an explanation? not a opinion.
Ruling, that was oh yeah, that's just the
It's an
explanation, that's
again,
correct, yeah,
rhetorical
yep,
response.
yep,
Okay, so
yep.
we skip on to 7.
Yep.
And we, if I'm not mistaken, no changes on 7.7, so we skip on to 7.8.
But 7.6 had, it said precursor to
Yeah, but
to a
that-
jurisdictional.
That was just her
Explanation.
explanation.
This is an
Back
explanation.
to-
Okay, okay.
This is a
It wasn't- right,
response to the,
right,
to the
right,
citizen
Right,
comment.
right.
Okay,
It can be. nothing.
7.8, what's that? No change?
No change, it is our
Okay, let's keep
responsibility to
moving.
determine. 7.10.a is the long sentence.
Okay.
And the question is, do you leave it
No,
long?
no, it's no
long.
change. If you turn the page, it says the attorney read it and reviewed
Yeah.
it without modification, recommend no change in the post language.
These aren't long. I've got my contracts I work with, 150 words is what I deal with. so.
Okay.
We agree it's
These are
long, but the attorney
Lincoln
reviewed
second
it,
and
no
I got
change.
it. Sentences, you know. The next one I have is section 10.
Me too.
Okay, that's good.
Replace Northeast Regional Planning Agency with Northeast Connecticut Council of Governments.
Yeah, that makes sense.
So wait a minute, I recommend no changes to the posted language. Except,
Except-
okay,
Except.
so we've already adopted, it. Okay,
Yeah.
we've adopted,
Right.
again, we've adopted Molly's recommendation, so no need to further act. We were affirming that recommendation.
Yes.
But you need to.
Yeah, right,
No
right.
changes, I mean, looking down, we're good, I think.
We're
Are we
good.
good?
So are we
down?
satisfied that we have
Connecticut Council of Governments.
sufficiently discussed the comments, the testimony of Marla Butts, the comments, testimony of Margaret Washburn,
I have.
citizens' comments. In that case, I am going to entertain separate motions. To begin with, I am going to entertain a motion to adopt the proposed revisions of the Thompson Inland Wetlands regulations as amended by the prior votes of this commission, including votes taken at this meeting and at previous meetings.
Commissioner Chapin, can I ask a question? Have we addressed Janet's desire for us to leave
me
this
too.
hanging in the air for 30 days? And can we make that, can we just, we can either do not say, too bad you had your chance, or do
Do
we
we even have to
say,
go address it?
I don't know that we need to address
Right.
it, but I just, okay.
This,
Marla Butts speaking.
Please do.
You already did, you closed
Yeah,
the
we
hearing.
closed the
Oh,
hearing.
okay.
She was asking for it
You
to
don't
be
have to say
extended,
anything.
but
Okay.
undefined
Yes.
time.
Better not
Okay, and we
say
close the
so.
hearing.
And-
Okay.
and-
Yeah, I don't like the idea of extending something to an undefined time. I just
Right.
want to make sure we had
Commissioner.
addressed that. I'm back with you.
Charlie over here. I made a point of asking earlier, after this meeting is over, it's up to us when we actually
Yeah.
vote on it.
Right.
So if we want to leave it open until our next meeting so that people like Janet Blanchett
But I
and
think
some of
we
those
just missed the
others that
point.
she
Yeah.
recommended.
Missed the point again.
Yeah, the public hearing is closed.
Closed.
The public hearing
public
is
hearing
closed.
is closed. I will,
No.
for the sake of clarity.
Oh, I see.
I
what
will
you're saying.
say, we could, I'm entertaining motions. If somebody wants to make a motion, second, it will vote. If somebody, if you're inclined to defer that final vote until our next regular meeting, where there's an opportunity, further opportunity for public comment and so on, that it's a possibility as well.
I mean, we already have the state reviewing it. They're gonna come back to us as Commissioner Chapin, for
Mhm.
those of you who are listening and taking notes. The state's already said that they will come back to us if they have a problem with it. We've had Marla review it with us through the whole process. We've had an attorney review it. We've entertained the comments. I think we should make a motion. I'll make a motion to adopt the.
Yeah, I'll second the motion.
Okay, the motion's been made and
So
seconded.
you can fill in the blank with what we're.
We have
adopting.
discussion.
Oh, any discussion? Thank
I have some
you.
discussion.
Go ahead.
Okay, so
I-
the regulations, just to recap some of this, the regulations have been worked on for months. We all been involved with this in a great deal of detail. Public notice was extended multiple times in different formats, both legal and other, and posted to the website. Legal notice went out twice. The recommended changes and the existing text were thoroughly vetted by subject matter experts, as well as legal counsel on this issue. The state agency, who has a responsibility and obligation to respond in a timely manner, well, we know the response is there, which is somewhat disappointing. However, they always have the right to weigh in on these issues. So delaying it for any reason would not make a lot of sense. There's no exigent issue before us that would require us to delay any issues, in my view. And the text of vetting, we've gone through in excruciating detail, the intent, purpose, clarification. So for these reasons, I would recommend that we should vote in favor of accepting the changes as discussed and as incorporated, enumerated during this meeting. Thank
Thank
you.
you. Any further
Yes,
discussion?
discussion point. When I was reminded that, in fact, the public portion of the meeting is closed, and we had 2 people show up after all that we did to.
Yeah.
And they both said, I should have done more homework. It is correct. The public hearing part is closed, and we've worked on this extensively. There can't be more than 2 or 3 small typos left.
There's always those, always that too.
There's always going to be 2 or 3. So, yeah, I'm ready to vote.
Marla, I'd like to make a comment, because you have suggested approving the regulations as you've agreed to here. I want to make sure that all the changes that you've agreed to, I understand that they are agreed to.
Right.
So I'm going to list them, and you suggest that you move to accept the regulations with the changes that I identified that I've collected from you during this proceeding. Otherwise, you don't know what the language is that you're actually approving, unless I make sure I itemize them, write down 1, 2, 3, 4.
Didn't we enumerate that during a prior discussion?
She wants to
Not
make sure
really,
she
because
has it.
there were some
Right.
changes that you guys
Right.
thought were appropriate for Margaret Washburn's communications, not just from Tira's.
Okay.
So if I could go through
Yes,
this, I will
please.
repeat what the changes are, and then you could move to approve the regs with the changes that I have identified.
I'm going to defer to my mentor chair. All right, so there is a motion on the table that
Right.
is
Do we
seconded.
renege that?
What do we do with that?
Well, you can withdraw it, and I believe. And,
Okay, so I'm gonna
retract it.
withdraw it and wait for,
Now you'll have to go to this proposal, then we'll go and
Okay.
vote on it.
approve it based
Yeah,
on what
right.
she
This point,
has
Marla is
reiterated.
enumerate
Yeah.
changes made to the previously approved revised regulations. Changes made at this meeting.
So the changes start section 1.2. The second line, quote, "These regulations," the word regulations shall be capitalized, and a global search and replace will be made throughout the regulations to capitalize regulations for these regulations. Second item. Page 9. Section 4.1 F. Third line down, the word subdivision shall be replaced with subsection.
Yes.
Page 11. Section 7.2. Third line down, the words site plan approval, comma, special permit or shall be replaced with the word the. And in the fifth line down, the words for the subdivision or re-subdivision shall be deleted and replaced with the words quote, with the Planning and Zoning Commission. Page 18. Item 8.6, the word open shall be replaced with available. Same page, page 18. Section 9.1. The paragraph after subsection C. The word, second word, a word that shall be added after the first word provided, so that it shall read,
Right.
public hearing provided that no petition provided for this section. Correct? Okay, page 19. Section 10.1, subsection C. The words regional planning agency shall be replaced with Connecticut Council of Governments.
Northeast Council.
Well, but it's
Northeast.
northeast,
It
northeast. in
says
both
northeast
places.
already.
But it says northeast in both
Already in there.
places, so northeast is staying, and the three words that follow is
Right.
being changed.
Page 25. Oh, wait a minute. Page 25, section 13.3, A, subparagraph A, second line down. The following shall be deleted after the word acceptable. Financial period A shall be deleted. So that it reads, if in the form of an acceptable financial guarantee issued by a company licensed to do business.
Oh, yeah, that part. Yep, I know where we are now.
Page 27. Section 14.3. A. Every place where there is a reference to hold a hearing or hearing, it shall be preceded by the words show cause. And then in section 14.4, the 1, 2, 3, 6th line down, the word public shall be replaced with, the public shall be replaced with a show cause, so it shall be read at a show cause hearing the permittee. And then there will be a space added in between the next line down between the words the and license near the end of the line.
Yep.
Yeah, Scrivener. That's all I have.
Thank you.
Okay, great.
I should now make a motion that we adopt the proposed provisions of the town planning and ordinance regulations as amended by prior votes of this commission, including votes taken this evening and at previous meetings, as enumerated by Marla.
Your motion?
Oh, okay, so I thought you just made the motion.
No, I'm entertaining.
Yes, so I'll make a motion that we accept the regulations as discussed in this meeting and enumerated by Marla Butts to the inland wetlands and water courses regulations.
I second the motion.
Any further discussion? All those in favor?
Aye.
Aye.
All those opposed? Motion carries.
Thanks for all that.
We're not quite done. I have to entertain a motion to adopt the new inland wetlands and water courses map, about which there has been
Oh,
a discussion.
Make a motion, we adopt the new water courses map.
A second motion.
Second, all those, any discussion? All those in favor?
Aye.
All those opposed? The motion carries. I will entertain a motion to adopt the proposed new application forms.
So moved.
A second the motion.
Any discussion? All those in favor?
Aye.
Aye.
All those opposed? The motion carries. And finally, a motion to establish an effective date for the revised regulations as required by the Connecticut General Statutes. I'm going to recommend, following Marla's advice, an effective date of July the 1st, 2024, to provide our new and wetlands agent with time to post new application forms on the website for public use in advance of the effective date. So to repeat, I'm going to entertain a motion to establish as an effective date for the revised regulations, July 1st, of 2020.
Second the motion.
Any discussion? Those in favor?
Aye.
Aye.
All those opposed? The motion carries. So prior to adjournment, I would like to extend the commission's and my own gratitude for Marla Butts for her expert
Absolutely.
guidance throughout this lengthy and rather difficult process in many ways, as enjoyable as it's been. Her skill at navigating its complexities has been truly impressive, and I'd like to enter that into the record. I shall now entertain a motion for adjournment.
Make a motion to adjourn.
I second it.
Seconded. All those in favor?
Aye.
Against. The special meeting of the Inland Wetlands Commission is now adjourned. Thank you all for your time and attention.